Hey everybody, my name is Ahmad here at S Group. I'm here with Alexi Silverman, family law attorney at Honest Law. How are you doing?
I'm doing great. How are you?
Doing incredible. Really excited for our topics today. I think this can help me out a lot, especially. Uh, so we're talking about prenuptial agreements and division of assets. I want to know, so should couples have a prenuptial agreement?
That's a great question, Ahmad. Yeah, I am always highly in favor of that. And just to comment a little bit on, kind of where family law has gone over time, I think, you know, my generation actually, to date myself a bit, I've been at this for over 25 years. And, when I came out of law school and, first stepped into this kind of arena, people definitely were getting married earlier. People weren't deferring the decision to marry. And, there was a little bit of an old fashioned, approach to things, which by old fashioned meaning, well, you get married the first time, you want it to be romantic. Why consider something like a prenup? Isn't that too formalistic, too legal? But I really think, and I've always thought that the proper way to think of a prenuptial agreement is not whether it is a romantic thing or not. I think it can be romantic if it's introduced in the right way. And let's face it, many people think it's romantic to have a conservative approach to a relationship. And probably the best way to do that is a prenuptial agreement, which, maybe the easiest way to think about it so people aren't thrown by those words is it's just a type of contract between the parties that affords a lot of certainty. And in that sense, it's like an insurance policy for the marriage. It's an insurance policy in terms of assets that you've accumulated. You want to be sure how those are going to be treated upon a dissolution of the marriage, and an ultimate divorce. And the only way to do that actually is through a prenuptial agreement, because otherwise you're dealing with the uncertainties of the legal process. You might find yourself in front of a judge who's, more or less, restrictive or liberal with respect to applying legal rules in states where judges distribute property on an equitable basis. They can have equitable considerations like, is it more or less fair to distribute X percent of property to one spouse or the other? And where I think prenuptial agreements I really see fitting in and being a great idea, particularly for the millennial generation, to circle back to what I was saying, is many people have deferred the decision these days to have enter a marriage. And then, increasingly common is marriages that are childless. So, you know both you find that, in today's work world, both members of the couple, it's, no longer a traditional situation where one spouse is the homemaker. In today's world, where there are all kinds of, later joined marriages, both members of the couple have accumulated significant assets. So, one example of where that makes sense, and, I'll just dovetail it with a recent client of mine, was a woman who was referred to me, and, she was getting married for her first time, but proposing to marry her fiance, who was just exiting his first marriage and going through a divorce. And she was particularly concerned that the first time she'd be married, she'd be able to protect her business, which, what she had, a multiple jurisdiction clinical health business based in, DC. And she wanted to know the best way, she could insulate that becoming part of a new relationship and proposing to enter marriage. So she retained me, and Honest Law worked on a prenuptial agreement that would protect her significant accumulated assets in the business. And, in some sense, some people might say, well, those were premarital assets. You don't need an agreement to protect those. That's only true to a degree. Once you start to commingle any assets or earned income from other businesses into, joint accounts, for instance, with your spouse, the lines can become blurred between what constitutes premarital property and what would be treated upon a divorce process as property of the couple, which family law attorneys refer to as marital property. So in this case, the only way to be sure of a treatment of an asset is by designating how it's treated in a prenuptial agreement. So, for instance, to the extent that there were to be any doubt about an asset, you define it in the agreement as premarital property. And so typically these agreements, just to give some basic understanding of their structure, will have attached schedules whereby it lists categories of premarital property. Now that could be, a condo or a home or other real estate that was purchased by one or the other spouse prior to marriage, accounts that were opened prior to the marriage that, are going to remain premarital property. And also businesses can be listed whereby, one spouse or the other, for instance, it can be any small business or any larger business, their stake or their equitable goodwill value in the business can be treated as premarital property in such an agreement. So, where that can significantly give you a leg up is that then when there is the decision, often a mutual decision to end the marriage, both parties will know where they stand. Neither party will necessarily need to spend much money on legal fees at that point because, in effect, it's a contract that says, here's how we're going to divvy things up after. And sure, one party or another can try after the fact to say, well, that's not exactly what I agreed to, or court, you need to interpret this prenuptial agreement. But, frankly, that's where having effective advice of a good seasoned family law professional like myself and Honest Law can really, really give you a leg up in the process, because we write, what I'll refer to as an ironclad prenuptial agreement. And I try to ensure that they're written in such a way that, no one can later, for instance, claim, oh, I signed this, under duress, or, I was harassed into signing this, or someone tried to, pull the wool over my eyes and deceive me into signing this. When it's done the right way, the disclosures are done all up front. And, I really stress with, clients of our firm, with clients of Honest Law, that, the key to making the prenuptial agreement as ironclad as possible is full mutual disclosure of finances. Just a little anecdote about that. It would not be full disclosure if, for instance, one or the other member of the couple to be had a cryptocurrency account that they cleverly thought the other party wouldn't learn of, and that, you know, they had been, you know, for years investing, you know, money in acquiring Bitcoin and had a huge, you know, windfall, you know, profit in their Bitcoin account that they didn't want, you know, their spouse to be to know about. Well, you know, if you willfully withhold information like that in the process of forming a prenuptial agreement with someone, and it were to be later discovered that account existed, you know, it's a problem then for the, you know, the integrity of the agreement, and for how a court, if it's later called upon to review a prenuptial agreement, would treat it. They could say that, you know, the agreement is null and void because there was no meeting of the minds, because in essence, the couples didn't know at the time, you know, the couple didn't have full mutual knowledge and information at the time the agreement was formed to allow them to, you know, make an effective agreement. So that's why, you know, I always counsel that to make these the strongest, you know, you really need to have full disclosure. And there's no harm in that full disclosure, because guess what? So what if you earn significant money in the Bitcoin market prior to the marriage? You can always list that account and designate it as your premarital property. Now, once you're married, thereafter, so long as you don't change the nature of that property, in other words, for instance, say you liquidated half of the Bitcoin account and moved it into a couple's joint authorized account. Well, guess what? Just by virtue of doing that, you could have changed the identity of the property from premarital to marital, because you moved half of it into a joint account. So in that case, you know, even if you do have a prenuptial agreement, you could possibly alter the status of a part of the agreement if you're not careful about it. So, you know, once again, you know, the benefits of the prenuptial agreement all come down to having certainty that if you follow the recipe or the plan laid out in the prenuptial agreement, you will know at the end of the day how things will be treated. You won't have the uncertainty of, you know, having an attorney tell you, like, look, we've got to wait and see, you know, what the judge decides about this. Or if you're unhappy with the trial judge's decision, then have the uncertainty about what higher courts on appeal could say. And, you know, frankly, those courts often defer to the findings of trial courts about, you know, how property should be treated. But if you've already addressed it in a prenup, then both sides, you know, parties to the equation, to the contract, will understand how that asset will be treated upon divorce, which lessens the amount of disputes, lessens the amount of fees that you would ultimately pay in the process of divorce. And, you know, about fees, I should just say, you know, I mean, in the last year or so, I mean, they say that, you know, sort of the median amount spent on divorces can be as much as $20,000. So, you know, would you rather spend several $1,000s, $2,500 to get a prenuptial agreement, which may mitigate how much you spend upon divorce? Or would you rather spend $20,000 or more later fighting about categories of finances that you could have addressed in the prenuptial agreement up front? So we're at Honest Law, we're big fans of prenuptial agreements, and we think they should be considered, you know, not just in second and third marriages, but in first marriages.
Okay, I got that. That was great.